Free fuck, mistrial. Free fuck, mistrial.
All right, Mr. Stevens, you can take it. Ladies and gentlemen, we're going to go ahead and take our comfort break at this point in time. We'll be back in 10 minutes. We're in recess.
Free fuck, mistrial. Free fuck, mistrial.
Hey, yo, you. Can you subscribe and turn on that bell too? Because when you do, you're helping unbiased, independent news.
Are you ready? Hey, think you can tell us what to do?
If you'd have told me when I was a little boy that I would not only become an attorney, but I'd also become a jurist at some point in time, I would have probably, no way. My name is Glanville. My military job is I am the Chief Judge of the U.S. Army Court of Criminal Appeals. My civilian job title is I'm a Superior Court Judge. I serve the citizens of Fulton County, Georgia. I found myself at 19 raising my right hand to join our United States military. I saw that as an opportunity for me to get the money that I needed to go to college and then go to law school. I've been in uniform nearly 31 years, and I've enjoyed it. It's been challenging at times, but I've been able to do what I love, and that's practice law in both the Army and as a civilian. The Army Reserve, it's part of the fabric of our nation. We have the duality of professions. Not only do I serve in the profession of arms, but I serve as a professional lawyer in the profession of law.
Incredibly proud of his achievements, and I really like how he's become such a great role model for our children to see what hard work and perseverance does and how it can benefit you if you continue to, keep your eye on the ball and be very focused.
I've presided over some pretty high-profile cases over the course of my 11 years in Superior Court. I think that part of the reason I was able to finesse those particular high-profile cases is that of the things I've learned in the military. Character, competence, and commitment are the underpinnings of not only being a good lawyer, but being a good soldier. It is very humbling and awestruck for me to be sitting here and talking to you as a general officer. I never thought I would serve over 30 years in uniform, but it has been you as a general officer. I never thought I would serve over 30 years in uniform, but it has been my honor to do so.
That's not what's on the table.
So, you said 28, right?
28, yes, at noon. Or you do 20 days.
I'm telling you, as the judge presiding over this case, if you do that, it's misconduct. I'm telling you right now.
I don't know what you're telling me. I'm not.
I am telling you, you have no good faith basis to this point in time to ask that question right now or to intimate that. You don't want to accept my ruling.
Your Honor,
and I know you're being an advocate, but at some point, stop. Just stop.
If the judge is that fiery, can we ask the question, why aren't we seating new jurors or doing a whole new jury selection? Because that opening statement was literally grounds for a mistrial.
Good morning again, Your Honor. Your Honor, last week, 2 weeks, 3 weeks ago, you ordered the parties to share all of their displays in opening statement to the others so we don't have to have these interruptions. I did that. The state shared with me 4 attachments. That's all they had. That's what I got. What you just saw on your screen, if you don't remember, I'll ask the state to put it up and I asked for it to be marked as exhibit, is what you already excluded. It states that Mr. Ryan was convicted of murder and I represent the co-defendant who's not on trial on the appeal. How did that not get sent to me so I could bring it to the Honorable Court's attention, 1? And 2, how do we just violate court orders? So, yes, I have a serious motion for a mistrial because it's intentional misconduct. That's my motion.
All right.
And I'd like the screenshot to be captured for Mr. Weaver to put in the record.
I'll admit it.
as a matter of course, I can again reiterate the fact that it was an inadvertent omission to leave Mr. Steele, at least part of his name on
I
here.
got that, but he's talking about, is there anything else you're going to use in open you haven't shown to defense counsel?
I
He's
don't
telling
mind
us,
sharing.
well, I said that. I told you to do that a week ago.
Your Honor,
Because here's what I told you was going to happen. I've got a jury that's out right now that's being interrupted. And Mr. Williams, you should have made your motion or should have told me about that an hour ago or when you found out about it. Not hijack me at the bench about that. You did what you had to do, but I'm not happy about that. I'm not happy about any of this. Because this is stuff we could take care of before our jury comes in. And that makes you all, lessen your ability as advocates and lessen our ability for this jury to go ahead and get this case seamlessly. This is what I told you all was going to happen.
All right, we're watching a controversial moment there during opening statements for the trial of Young Thug. I want to bring in ABC News legal contributor Brian Buckmeyer to break down a little bit of what happened. Brian, they're 5 minutes into opening statements, and we're seeing the defense make a motion for a mistrial. What happened?
So, if I can explain this. And excuse my laughing, because it's just so ridiculous. It appears that the prosecution turned over only some of the information they were going to present in opening statements. That's not the way it's supposed to work out. You show the defense attorneys, and when there's so many of them, you have to show them all, what they're going to present, what information is in that. And here, there's the mistake that they simply put out that there's a connection, not just between YSL, but also between Young Thug's own attorney, that he represents another defendant on an appellate issue that the judge has already ruled should not come in. Why is that such a big deal? One, you have to give this information to defense beforehand. Two, the judge made a ruling on this, as he explained about a week or two ago, that the only way that the prosecution can bring this in is if they lay the foundation to that. Why is it such a big deal? Some of the rap lyrics that they're using against Young Thug says that he pays for lawyers to help with killings. This is something that will definitely prejudice the jury, and the judge, I think, understandably doesn't want a mistrial because they just started after almost 10 months of finding a jury. Now, about 10 minutes into the opening statement by the prosecution, we're already having issues. This is a huge fumble by the prosecution.
So now what do they do? Because the jury was there. The jury saw that slide. So how do you fix that now?
So we call it a curative instruction, but most attorneys will tell you you can't unring that bell. The jury was stepped out for a few moments. They know something is wrong. They know that the last piece of information that they saw or heard is a major issue. So it's going to draw their attention. But now the judge has to explain, hey, we know that one of the defense attorney is named here for representing someone else, and the prosecution is going to later come and say that his client pays attorneys to get other people off on murder, but just don't look at the man behind the curtain type of situation.
Does this open grounds for appeal if he's convicted?
Absolutely. This is just one of many. And a defense attorney or prosecutor being yelled at by a judge at any time, but especially this early, does not bode well for the prosecution side.
Now, the reason why I keep telling y'all certain things will not happen is because of pattern of behavior. And the biggest pattern of behavior to fault from and fall from are literally the ones where you learn the most from. We've heard so much about a mistrial, and we couldn't figure out why he wouldn't grant a mistrial until today. Take a look. Atlanta, Associated Press. A woman pleaded with the Georgia Supreme Court not to let the man accused of killing her mother go free because of a judge's mistake during his murder trial. But the High Court on Monday said a judge can't set a new trial for Gary Otis after having erroneously declared a mistrial in his case nearly 2 years ago. Otis is charged with murdering, in the slang of 75-year-old Mary Oliver, an aggravated assault, and an attack on a 71-year-old Emmanuel Surrey. It was a mistake on the judge's behalf. By all means, sanction the judge and give it to another judge, Oliver's daughter, Jan Jacobs, said through tears at a news conference Tuesday, but he should not walk free. What kind of message does this send if we just let murderers walk free? It all began June 17, 2023, when police said Gary Otis ran up the stairs of a high-rise apartment building for seniors and stabbed Surrey before kicking down a metal door and fatally stabbing Oliver. Police had to use a stun gun to subdue him, according to court records. Otis, who was 64 at the time, was a resident in the building but didn't know Oliver or Surrey. Fulton County District Attorney Paul Howard said Oliver was asleep in her bed and Surrey had just returned from taking his uncle to the hospital. Otis was arrested and jailed. When his murder trial began April 7, 2024, public defendant Amanda Grantham told the jury in her opening statement that Otis just snapped. The only possible verdict is not guilty by reason of insanity. Grantham told the jury. Prosecutors were caught off guard. They objected, saying they hadn't been notified of an insanity defense and needed more time to prepare. Grantham says she wasn't required to give them a heads up because she didn't plan to call any experts. Fulton County Superior Court Judge Glanville said he believed the law required prior notice. He hadn't wanted to keep jurors long enough for the trial to be rescheduled, so he declared a mistrial. He said he'd put the case back on his trial calendar in a couple of weeks. Grantham didn't want a mistrial, though. She challenged the judge's decision. She argued that a jury had been seated and the trial had begun, and retrying Otis would amount to double jeopardy, which is when a person improperly tried twice for the same crime. Glenville rejected that argument. Grantham appealed to the state Supreme Court, which on Monday said the judge had erred in reversing his ruling. The justices said a 1995 ruling makes clear that the defense doesn't need to provide notice of an insanity defense if no expert witnesses are to be called. That opinion came during the sentencing phase of a death penalty case, and Glanville interpreted as only applying in that context. The Supreme Court disagreed. In this concurring opinion, Justice David Nemes said the Superior Court rules needed to be revised. It is apparent that the trial court in this case was striving to produce a fair trial, but the court erred in not abiding by our holding in the earlier case, Nemes wrote. Glenville declined to comment through the Superior Court's public information officer. Howard said the court's ruling is beyond belief and shocking to the consciousness of justice and fair play. He said his office will request reconsideration. If the Supreme Court declines to reconsider its unanimous ruling, Otis will likely be released in several weeks after being in jail for 3 years. The social workers and the public defender's office are working to set him up with the help he needs. Brian Gathram, the husband of Otis' trial attorney who joined a case on appeal to help his wife, said he doesn't believe Otis will be a danger to anyone because he didn't have a violent history. I think it's just a little shock because he's been sitting in jail for 3 years and honestly probably thought he was never getting out of custody. Brian Grantham said, now he's got a second chance at life. So there you have it, folks. That man got out, hasn't been seen since, and will not be retried. And I'm going to be honest with y'all. That's pathetic. Now, people are going to want to blame the judge. I don't see it that way, but if you do, you do. And I can understand why you want to blame the judge, because the judge literally got to the end and said, no, we have to give a new mistrial. We have to give this a mistrial. That's why he won't do it. Because the time that he did grant a mistrial, they let a killer go free. So y'all tell me, are you that upset? Are you truly that upset? Because had the judge never granted a mistrial on that, then that's what would have happened. Then it could have been out of his hands, and then they could have tried it on an appeal. But they didn't. Can't go back and arrest the man who killed that woman, Otis, because it'll be double jeopardy. It's one of those rare instances where you blame the rich because the rich write the laws. They do, because they spread propaganda. See, a lot of y'all believe out of your heart of hearts that you don't have choice when you do. It's just the messaging that gets put out there allows you to be swayed a certain type of way. You know, a low 40% of Americans vote. Did you know that? A low 40%, like 42, 43%. Which means that over half of people decide to do nothing that could vote. Those are laws that need to be changed. Laws or by the people. And that's just an effed up law. So there you have it, man. He won't grant a mistrial because he's afraid of what could happen. Remember, Finding Willis painted the illustration of Young Thug being some criminal mastermind, the head of a criminal enterprise that commits shootings and murders and all of these things. But based off what we've seen, that still has yet to be proven. But share to keep your people aware. Subscribe, turn that bell, stay notified. If you like stuff like this, I'm working on a big Marvel MCU thing over there on the Seti Nash Reloaded channel. So I'll just be ready for that, man. I don't know, bro. I'm gonna do pretty well at this. I'm gonna try something different on another platform that isn't monetized, so that y'all can enjoy it without the commercials and I can go crazy. Appreciate y'all. Y'all have a great Sunday.